All right. Happy Saturday or Sunday or whenever it is that you are logging on to watch this. I apologize I didn't get it done last night. There was a hockey game on, and, well, let's be honest, we all have priorities. Today what I want to make sure we get through is this idea of the rights of the accused. So what we're talking about here is an individual is accused of a crime. Now again, remember back to how all of this stuff connects together. So what we've been talking about this entire unit is the idea of where do our freedoms end. And so we automatically have to deal with the fact that individuals will violate these rights. Those are people who commit crimes. Those are people who violate social norms. Now, remember, when we established this Bill of Rights, our biggest concern was tyranny, abuses of power. And you think back to things like the Third Amendment, where the government had forced quartering to prevent people from rising up and speaking against the government. You think about what's going on in other countries. Today we're talking about things like Ukraine, things in the Crimean area. We're talking about Russia intervening. And so what we want to worry about is political dissent. We can look at examples in North Korea where somebody has spoken against the leader and then they just disappear. So our founding fathers knew that this was a way to prevent political discourse, to prevent people from speaking against government abuses. So what they wanted to do was make sure that if we are going to take away someone's freedom, if we are going to take away someone's liberty, that they have had, to the best of our ability, a fair trial. And we'll speak more to this when we get to our legal unit. So, as we go through these rights, we want to think about this in the context of preserving freedom. The Fourth Amendment. Now remember, we don't want to write all this stuff down, but what we want to be able to do is discern from this text, and this is the original text from the Bill of Rights, what exactly it is we have protected. So, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Now, if we think about that, none of those words separated are words that in general we have a hard time understanding. Really, the Fourth Amendment comes down to one thing. You as a citizen have a right to privacy. And in order for our government to violate that right of privacy, we have to have a reasonable suspicion supported by evidence, or at least what we would call probable cause, that a crime has been committed. So what does the Fourth Amendment really mean? Well, it just simply says, what does a policeman need in order to search your home? Well, you guys have watched enough Law and Order. You guys have seen enough movies. That's pretty easy. It's a warrant. But the key is this. The warrant is not granted by the police. Again, we see a check and balance put in place. The police are a subset of the executive branch. Again, if we look at the president, he is in charge of the FBI. But the FBI, in order to grant or to gain a legal warrant to search you, need to have that done so by a judge, which is the judicial branch. So again, we're seeing all of these steps put in place to make sure that the police and our government does not abuse its power. So they need what we call probable cause. In other words, is there something likely that's going on? At school, if I see a student doing suspicious behavior, that's probable cause. Again, remember, at a school, I have to have a lesser threshold than what a police officer does, because you check more rights at the door when you walk into a schoolhouse. But in general, seeing a lighter is enough to do a full search of a student, including their backpack, their vehicles, all those kind of things, because I now have probable cause to think you have illegal substances. That doesn't mean it's automatically marijuana or some form of illicit drug. It absolutely could be cigarettes, but regardless, you are not allowed to have that on school grounds. Probable cause simply means this: a reasonable belief that a person has committed a crime. That's all it takes. Students acting in a suspicious manner. Students with, if you smell smoke, if you smell alcohol, if you see some of those telltale signs of drug use, that's enough to search things. And again, remember though, it does take more for a police officer to search you than just a principal. All right, that's it for the Fourth Amendment. Like we said, some of these are going to be easy. Now, the Fifth and Sixth, to be honest, are where a lot of people are going to get confused. So let's make sure we pay attention and we think about ways that we can organize these thoughts into our head to differentiate between the Fifth and the Sixth Amendment. So, lots of stuff here. Number one, no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury. All right, there's one right. Now, the key word that's going to be a problem for some of you is the idea of indictment, and we've covered that. The other term is capital, and capital has a bunch of different meanings, but in the context of legal talk, capital simply refers to something that is a major offense, potentially where we could execute you. It is a capital crime. There are some exceptions in this, in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. All right, this is where we get issues, pardon me, issues dealing with Edward Snowden. So now those are those military cases? Are those things where he's engaged in war, or is it creating a public danger? Second thing, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. That's a second right. Number three, nor shall be compelled in any criminal case to be a witness against himself. That one's pretty easy. We've heard that plenty of times on TV. Next one, nor be deprived of life, liberty, or property without due process of law. So there we see the term due process. So when we say deprived of life or liberty, we're saying execute or put you in jail. That's the liberty part, take away your freedoms. Or property, that's where we confiscate your stuff. There's another right. Nor shall private property be taken for public use without just compensation. All right, so we have four rights that really make sense and fit with this. And then the fifth right in the Fifth Amendment is kind of tied onto this, but in modern times, we don't really deal with that in terms of crimes. All right, what do we have then? The first thing to remember is there are 5 rights in the Fifth Amendment, okay? Some of them you are very, very familiar with. The first one, federal trials require an indictment. Remember, the C is silent because English is stupid. Federal trials require an indictment of a grand jury. We're not really super concerned about a grand jury at this point. We'll talk about that in the next unit. What we know is that if the federal government is going to try and put you in prison, they have to have a separate segment of the government, the grand jury, to say you officially have been tried. That's what an indictment is, a formal accusation that someone has committed a crime. Now, that doesn't mean you're guilty. It just means we have to say that you are officially accused so we can go to the next step. Second right, and you guys know this, double jeopardy. You've heard that term before, I'm assuming. You cannot be tried for the same crime twice. So, you are accused of murder. You have a trial that has been deemed a fair trial, and you are found innocent. Our government cannot keep trying you over and over and over again until they get a jury that agrees. Now, many of you are going to start asking questions about appeals process. Well, what if you appeal? We've talked about appeals court. Isn't that a second crime or a second trial? Think about why an appeals is not double jeopardy. If you can't figure it out on your own, when we come back to class, ask me about it. We'll obviously cover that in a review. But the big thing is you should be able to use logic and reason to understand why an appeal is not double jeopardy. Third right in the Fifth Amendment. You don't have to testify against yourself. So you have evidence about yourself that might make you look bad. Well, you can plead the Fifth Amendment and not testify. Now, that doesn't mean that you are out of jail. Obviously, with a jury, if you're not willing to testify, then that looks pretty bad. That's incriminating. That doesn't mean, though, that it's still not a good defense. If you have stuff that will make it look worse, even if you're innocent, well, then you definitely shouldn't give that information out. Fourth right is you must have due process of law before you are convicted. And due process is not a single thing. It is not like, oh, now you've completed due process because you went to this step. Due process is all of the steps from the moment that you encounter law enforcement dealing with a crime until a jury has said you are guilty and an appeals court process goes through. So in other words, it's every step in between. From the minute a crime has been committed and you are subject to police authority until the final jury verdict. That whole thing is due process. So think about the process that you are due once you're convicted of a crime. So those are the 4 that really make sense. The 5th one is a little bit goofy because it doesn't seem to tie into this. The 5th one is that the government cannot take your land unless it pays you. Now, why would the government take your land? Let's say we needed to build a highway. Or Hastings, we needed to build a bridge. And let's say one person owned a little piece of land that prevented this bridge from being built because they're trying to hold the government hostage. They're trying to make a lot of money. This is their financial grab. We have a provision that one person cannot do stuff in their own interest that is not completely detrimental to society. Well, this gets really, really controversial. There's a bunch of stuff going on right now in Spring Lake Park dealing with the bike path in Dakota County. So we'll actually take a look at that when we get into our next unit. All right, that's the fifth. Fifth Amendment, again, there are 5 rights in it. And think about what they deal with. One of them really doesn't make sense. Sixth Amendment then. Again, dealing with crimes and the trial process, this whole idea of due process. This is why the 5th and 6th get mixed up. Let's start with this. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law and to be informed by the nature and cause of the accusation. All right, right there we have 2 rights within there. The first one is where we get the idea for the 7th Amendment later in non-criminal prosecutions, in other words, in our lawsuits and civil trials. Then we have a second right within that. Remember, I'll go through these. Then, and to be informed of the nature and cause of the accusation. You need to know what the word accusation is and understand the context of the word nature. Third, technically fourth, to be confronted with the witnesses against him. Notice they use the word him. It's kind of always interesting when we see how gender biased this stuff was, but that's for psychology. Take my class senior year and we'll talk about it. Next, you have compulsory process for obtaining witnesses. Compulsory means forced. You can compel someone. You can force somebody to do something. So for obtaining means to acquire, to gain, to get access to, in this case witnesses in his favor, and to the assistance of counsel for his defense. Counsel is what we term lawyers, legal counsel, someone who will help you. So we have a number of rights in the 6th Amendment. All right, what are they? Number 1, you have the right to a speedy trial by an impartial jury. Impartial means that they're not favoring either side. They're fair. Now, why is a speedy trial important? Because without that, if the government is unhappy with you for a variety of reasons, they could put you in jail and say, yeah, your trial will be in 10 years. And that's what we saw happen in feudal England, in feudal Europe. We see these other countries where we had rights of citizens trampled on by oppressive governments. And so, yes, you could have due process, but without the right to a speedy trial, hey, you're never going to get the end of due process. And you've still lost 10 years, 15 years of your liberty, of your freedom. Next, you must be told of the charges against you. Think about how unfair it is of your parents, but how smart it is on their part to say things like, all right, is there anything you want to tell me? The first thing you do is you sit down and go, oh, uh-oh. And you sit here and run through all of the things in your head, and your first thought is, what do they know? And you have no idea what they know, but they make it seem like, hey, they know, and the best thing you can do is tell me. Well, the government can't do that because the problem is all of a sudden we get into potential problems with the 5th Amendment. If you're going to be charged of a crime, we have to tell you what it is so you can mount a proper defense. You must be provided a lawyer if you cannot afford one. Why? Because the law is incredibly complex. I got to tell you, I've taught law for 7 years now. 6 years, because my first year I didn't. 6 years. My degree is actually close. My degree absolutely works as a pre-law degree. I could use this to apply to law school. If I'm accused of anything more serious than a traffic violation, I am getting an attorney. Why? Because the law is incredibly tricky. And so you need someone who is practiced in it. Some of the greatest lawyers in American history, when accused of crimes on their own, the first thing they do is hire another lawyer to help them, which should say something. All right, 8th Amendment then. Last one that we're going to deal with in this, 4, 5, 6, and 8. By the way, as I go back with the 6th, you can see it's really just 3 rights. So the 6th Amendment has half the number of rights in the amendment. The 5th Amendment has 5 rights, 5th and 5, 6th and 3. Now I know that stuff is goofy. I'm just trying to throw anything out that will help you with this. Okay? The Fifth Amendment deals with this whole overarching theme of rights once you're accused of a crime. The Sixth Amendment, if you look at it, really is what happens once you are accused of a crime. The Sixth Amendment kind of details a lot of what due process deals with. Now, the Sixth Amendment also implies things like, or says stuff about you can get a witness or you can make somebody come. So there's other sub-rights within there, and I get where that sometimes gets confusing. But what I would say is just make sure we have a general understanding of the Fifth outlines the process. The Sixth goes into more detail of due process. Eighth Amendment then. So now the Eighth Amendment deals with you have been convicted of a crime. What can and can't our government do? One, excessive bail shall not be required. Now that one deals with before the crime, but the rest of the Eighth deals with afterwards. No excessive fines imposed, nor cruel and unusual punishments inflicted. And this is where things get a little bit controversial, because it's open to interpretation. What is cruel? What is unusual? Unusual is different based on today than it was 200 years ago. So we'll break this down first. Actually, I'm going to back up real quick. When we talk about excessive bail, here's what we mean. Let's say you are accused of stealing, $200. Well, we can't put you in jail and put a bail. Bail is what allows you to be out of jail until you are convicted of a crime. We can't put a bail on you of $5 million. That's excessive. It doesn't fit the crime. And then once you are convicted, let's say you're convicted of stealing $200, yes, you can be charged and fined more than $200, but we can't fine you $5 million because you stole $200. Now the cruel and unusual punishment is the one we get into debates about, and that really deals with the death penalty more than anything else. So the next images, I apologize in advance for some of you. These are pictures of punishments our government has legally carried out. And then the debate we have to as a society have is this cruel and unusual punishment? The first image is a real image of someone who was convicted of multiple murders and then was electrocuted. Now we as a society have to determine if that is cruel and unusual punishment, if our government has violated that, and most states have said no. In the past, in addition, we have done things like this, where we put people in the stocks, where they are posted high. If you look at the top, on the right, you see people in stockades. Now the problem with this is, imagine as soon as your legs get tired and you start to drop it, your head is through wooden bars, you will choke yourself. There was no real way to hold yourself out without your legs. There's no way you could sleep. So this is something we've absolutely banned. If you notice on the bottom, we have somebody whipping somebody. These are things we have outlawed. So the question is, looking at these two, why as society have we determined one on the right is cruel and unusual, and one on the left in general isn't? All of these rights then combined, we have to think about what the purpose is. These are things we define as civil liberties. Civil meaning society, how we get along, and liberties meaning freedoms. And so in general, what we look at in amendments 1, 2, 3, 4, 5, 6, 8, and 9, what we've really talked about is the idea that citizens should be free to think what they want, to act how they want, without being worried, without fear of the government interfering in our lives. Now, as we've talked about and stressed, every single right has its limits, but those limits are not where the government finds fault with them. Those limits, again, are where other people's rights begin. And that's so important, and that's what the Ninth Amendment dealt with. Again, you get to think whatever you want, in all honesty. There is no limit on what you can think. You can say almost anything you want to. You just can't say stuff that violates other people's rights. You do not have the right, walking down the street though, to not hear things that offend you. And so you're going to, in society, hear things you don't like. You're going to see stuff in movies, on TV. You're going to have all of these things that you don't like. That does not violate your right. You do not have a right to like everything around you. What you do have a right to is to feel safe and secure. And so when we talk about this, we can go from thought to speech to actions. And actions are where we start to really limit people. And that's simply because those actions tend to be more likely to interact with other people. And your actions cannot interfere with my rights.